Welcome everyone. My name is Rebecca Hoyt and I will be facilitating the webinar today. Before we begin, we would like to talk with you about some of the accessibility features of this webinar. To select a language for this webinar, please move your mouse to the bottom of your screen. You should see a toolbar with a globe icon that says Interpreter. Select English or Spanish, then click the option at the bottom of the same menu that says Mute Original Audio. This will allow you to hear the presentation in the language of your choice.
Buenos días y bienvenidos a la capacitación de hoy. Vamos a repasar algunas instrucciones para cómo elegir la opción de interpretación de inglés a español. Para elegir un idioma en esta capacitación, por favor, pose su puntero de computador hacia el fondo de la pantalla. Debería haber una barra de navegación con un icono de un mundo que dice Intérprete o Interpreter en inglés. Elija inglés o español. Luego haga clic en la última opción del menú que dice Mute Original Audio, que significa poner en silencio el audio original, que sería el inglés. Esto lo permite escuchar la presentación en el idioma de su preferencia.
If you are having difficulty selecting a language, you can join by phone and select either 1 for English or 2 for Spanish. The phone number is included in your registration email.
Si está teniendo dificultades en elegir un idioma, puede unirse a la capacitación por teléfono y presionar el número 1 para inglés o el número 2 para español. El número de teléfono está incluido en la registración de correo electrónico.
You should also see an ASL interpreter on your screen. If you would like to enlarge the interpreter screen, you can click and drag the corner of the interpreter's screen. You will also have a box on your screen for closed captioning. If you are having difficulty with any of these features, please let us know in the Q&A. The Q&A icon appears towards the center of the toolbar at the bottom of your screen. Only you and the facilitators will be able to see questions you include in the Q&A. We are glad that you are all joining us today to discuss reasonable accommodations in the workplace during COVID-19. We at Disability Rights California recognize that people with disabilities are facing unique challenges during the COVID-19 pandemic. According to the Bureau of Labor Statistics, of the 5 major occupation groups, people with disabilities are more heavily concentrated in service occupations than those without disabilities. This means that many people with disabilities are essential workers, are critical to keeping society functioning, making sure our community is safe, healthy, and that we have access to the resources that we need. On behalf of DRC, we want to thank all of the essential workers who are there for us every day and let you know that you are not alone. If you are working, you may have concerns about your health and the health of your family members. We want to be responsive to your needs and ensure that you have the information you need to be a strong self-advocate during this difficult time. Disability Rights California is a nonprofit legal services organization founded in 1978 that advocates, educates, investigates, and litigates to advance the rights, dignity, equal opportunities, and choices for all people with disabilities. This webinar is the second session of a 4-part series on employment issues important to people with disabilities during the pandemic. Some of today's topic will be discussed in more detail in later sessions. Last week, we held a webinar on COVID-19 employment and Social Security benefits. If you were not able to attend, a recording of the webinar and materials are posted on our website. Next Tuesday, May 12th, we will be hosting another webinar about services for people with disabilities who are seeking employment. And on May 19th, we will hold an additional webinar about services to help you keep your job. Please visit our website at www.disabilityrightsca.org for more information and to register for future webinars. We will show you where to find more information about upcoming webinars at the end of this session. Please note that we will be recording the webinar and your microphone will remain on mute until the presentation has ended. We will hold a brief Q&A at the end of our session today. We invite you to type your questions into the Q&A. If we are not able to answer your questions or you would like to speak to an advocate, please contact our intake line at 800-776-5746. You may also request help on our website. Our presenters for today's session are Aisha Nowowski, Pamela Cohen, and Stephen Peters. Aisha is a staff attorney in the Civil Rights Practice Group in the Ontario office, where she litigates discrimination cases statewide. Aisha received her BA from California State University, Fullerton, and her JD from New York Law School. Pamela is a part-time attorney focusing on training people with disabilities, advocates, and others on disability discrimination and reasonable accommodations. She is also a mediator with the California Department of Fair Employment and Housing. Stephen is a staff attorney working primarily in the Client Assistance Program. Prior to joining Disability Rights California, Stephen advocated for the rights of individuals under guardianship and conservatorship at Disability Rights Oregon. Now, without further ado, we'll begin our session on reasonable accommodations.
Hi, everyone. This is Pamela Cohen. Thank you for joining us today. I'm going to give you a little bit of background on the topic of reasonable accommodations in the workplace, and then I'll turn it over to Aisha and Stephen to talk about it in more detail. What we want to accomplish today is to give you an overview of the rules and regulations in this area and the protections in the workplace that are specific to the COVID-19 era, along with the general overview of what reasonable accommodations are and how you can enforce your right to be free from disability discrimination in the workplace and specifically to reasonable accommodations. Next slide. So the area of disability rights in general is a combination of federal law and state law and also some local law. And I just want to talk a little bit about that to give you some background in the area. There are laws at both the federal and the state level. There are regulations that go into more detail about those laws, and then there are agencies that enforce those laws. Next slide. These are the agencies at the state and federal level that enforce our, excuse me, employment discrimination laws. The EEOC, the Equal Employment Opportunity Commission, is the federal agency that administers and enforces the civil rights laws against workplace discrimination, in particular the Americans with Disabilities Act, which we'll talk about soon. The California Department of Fair Employment and Housing, or DFEH, is the state agency that does the same thing. DFEH, by the way, also enforces discrimination laws in other contexts, housing and housing discrimination, discrimination by businesses, and discrimination by government entities. It's not only employment and housing, that's just the name of the agency. And so it's important to understand that the federal laws that are administered and implemented by the EEOC are what we call a floor, not a ceiling to your civil rights, meaning states cannot be less protective of workers than what the federal law requires, but states can have laws that are more protective. And California does have laws that are somewhat more protective than what you're gonna see in the federal laws. And so we'll be talking about that soon. And then there are also local city and county rules in this area involving COVID in particular that again can be more protective of what the state requires and what the federal law requires, but cannot be less protective. Next slide, please. The federal law is the Americans with Disabilities Act, or the ADA. The ADA is divided into chapters that are called titles, and different titles apply to discrimination in different contexts. And so in employment, we're talking about Title I of the ADA. The ADA prohibits most employers with 15 or more employees from discriminating against people with disabilities in job application procedures, hiring, firing, advancement, compensation, and other conditions of employment. So essentially, the ADA requires that employers who have more than 15 employees treat employees with disabilities, and also job applicants with disabilities, equally to other employees. And that includes making reasonable accommodations, which are changes in the way that the workplace operates, as necessary for employees who have disabilities. And Aisha and Stephen will talk more about that. Next slide. California state law is the Fair Employment and Housing, previous slide. The California's Fair Employment and Housing Act, or FEHA, is the equivalent to the state equivalent to Title I of the Americans with Disabilities Act. It's very similar to the Title I of the ADA. It prohibits disability-based discrimination in all stages of the job process, from job application to hiring, firing, advancement, compensation, and other conditions of employment, all the way through termination. That's the same as the ADA. The difference is that it applies to employers with 5 or more employers rather than 15 or more employees. The reason these slides say most employers is that there are some exceptions for religious entities that are employing people. That gets really complicated, and that can be different at the state and federal level. So that's where the most comes from. Next slide, please. For all of these laws, the person who is protected against discrimination has to be a person with a disability as defined by the law. The definition of disability under the state and federal laws is very similar, but not exactly the same. Under both laws, a disability is a physical or mental impairment or condition that limits a major life activity. Under federal law, the condition has to substantially limit the major life activity. And under state law and California law, it only has to limit a major life activity. And limiting a major life activity means that it makes the achievement of that activity difficult. And major life activities include things like standing, lifting, reading, breathing, walking, paying attention, communicating, and also includes bodily functions like immune system functions and other functions of various types of organs. So it's pretty broad. Next slide. Okay, so I'm going to turn it over to Aisha now, and I'll be happy to answer questions at the end. Thanks.
Hi, this is Aisha. So I will be talking about some protections in the workplace during COVID-19. I do see that there is already a question in the Q&A box. I think a lot of the questions that folks have will be answered throughout the presentation. And just to let you know, the presentation is set up in a series of hypotheticals and answers. So some of the questions might be answered that way. We don't expect you to know the answers to the hypotheticals, but that's the way we've set it up. Okay, next slide. So Governor Newsom on March 19th, 2020, issued an executive order that essentially said that all people living in California must stay at home unless for an essential activity. That may include going to work, going to the hospital, going to a doctor's appointment, groceries, things of that nature. The order is currently in effect until further notice, and it is constantly changing. There might even be some changes or modifications to the order this week. So that's just the starting point, is the executive order that the governor issued. Next slide, please. So who is an essential employee? An essential employee is someone whose work is so important to our country and to our state that if they did not go to work, it would have a negative effect on the security, the economy, the economic security, public health, or safety of the state and of the country. So an essential employee can be a healthcare employee, someone that works at a doctor's office or a hospital, nurses, physician's assistants, people of that nature. First responders, such as police officers, firefighters, food and agricultural workers, so that includes farmers, that would include the grocery store clerk, folks that are in those positions. And transportation employees, bus drivers, people that operate trains that transport food from one location to the next. The link at the bottom of the slide has a list of all that the federal government considers an essential employee. Next slide, please. So this is our first hypothetical. Michael works at Trader Joe's. When Michael gets to work, his supervisor, Joe, takes Michael's temperature. Is this considered unlawful? Next slide, please. So generally, measuring an employee's temperature can only be performed under limited circumstances. But due to the COVID-19 pandemic, state and federal guidelines have determined that an employer may take an employee's temperature to determine if that employee's presence at work is a risk. If that employee is considered to be at risk not only to their colleagues, but to the people that they come into contact with every day, that is the need for the employer to take the temperature, and it is acceptable during these circumstances. Next slide, please. So as a follow-up to that, Joe has asked Michael to wear gloves and a mask at work. Is this situation considered unlawful? Next slide, please. An employer may require an employee to wear personal protective equipment to lower the risk to others that the employee comes into contact with during the COVID-19 pandemic. However, the employee may have to provide the employee with an accommodation if needed. So in this hypothetical, if Michael was allergic to latex gloves and he needed gloves, as different types of gloves, as an accommodation, his employer, Joe, would be required to provide him with that accommodation. So we're going to talk more about reasonable accommodations later, but this is just sort of a preview as to some hypothetical situations that may occur, and instances that you may have heard of or personally know about. Next slide, please. So in this next example, we have Zara, and she's an employee at Southern California Edison in an office with 20 people. Zara tests positive, excuse me, for COVID-19, and she tells her boss, Ed. Can Ed tell, excuse me, Zara's coworkers that she tested positive for COVID-19? Next slide, please. So as Pam discussed, there's the Americans with Disabilities Act and the Federal Employment and Housing Act. Under both of those laws, employers must keep an employee's medical information confidential. This requires the employer to store medical information separate from an employee's personnel file. In this situation, an employer may disclose to other employees in the workplace that someone tested positive for COVID-19, but Ed cannot identify Zara by name, and he cannot give any identifying information that Zara's colleagues would know it was her that tested positive. He has to keep that information confidential, but he can let the employees know so that they are aware they have been exposed to COVID-19. Next slide, please. So as a follow-up to that, can Ed notify the local public health agency that Zara has tested positive? Next slide, please. Yes, an employer may disclose an employee's name to a public health agency. And this is so that the public health agencies can keep records of who is testing positive, the demographics of the person that tests positive, and to have that information to ensure that others are staying safe and that we're staying aware of everything that's going on during this pandemic. So Ed would be able to report that Zara tested positive to the local public health agency. Next slide, please. So we have another hypothetical. In this situation, we have Andres, and he is a 67-year-old front desk clerk at TurboTax in Los Angeles. Andres is a non-essential employee, and TurboTax is closed. But Andres' employer wants him to be the only person in the office to answer phones and make appointments with people that walk in. His boss refuses to provide Andres with personal protective equipment. Andres' boss says if he does not do what he says, Andres will be fired. So in this situation, what should Andres do? Next slide, please. First and foremost, Andres should stay at home. And there's many reasons why. As discussed earlier, there is an executive order. And so since Andres is a non-essential employee, he needs to comply with the executive order and stay at home. In addition to the executive order, there are local regulations, and LA County has a stay-at-home order. So Andres would need to comply with that as well. It's also important to note that Andres is considered high risk for severe illness from COVID-19 because he's 67 years old. And so it's important that he stay home also for that reason. So another part of the hypothetical was that Andres' employer did not want to provide him with any personal protective equipment. Currently, LA County requires everyone to wear a mask when they leave the house. So in this situation, Andres, he has to have that personal protective equipment because it's required by his local government. But as mentioned before, the overarching issue is that even if his boss were to provide him with the personal protective equipment, making Andres go to work still violates the stay-at-home order that the governor has issued and also the stay-at-home order of LA County. In this situation, Andres may file a complaint against his boss with DFEH or with EEOC. It's important to note that even though there are regulations, federal regulations that affect the entire country, state regulations and orders that Governor Newsom has issued, but various counties and even cities within those counties have regulations as well. So it is important to check the rules and orders of the city you live in, the county you live in, to make sure that you're up to date and in compliance with those rules. Next slide, please. So now I'm going to go a little bit more about go in a little bit more depth about reasonable accommodations in the workplace during this pandemic. Next slide, please. So what's a reasonable accommodation? The law requires employers to provide a reasonable accommodation to an employee or a job applicant with a disability, unless doing so would cause an undue hardship. Next slide, please. The definition of reasonable accommodation is a change or exception to a rule or policy that is necessary to give employees with disabilities the same benefits that employees without disabilities have. Next slide, please. An undue hardship is if the change or exception to the rule or policy would create a burden to the employer or threaten the health or safety of others, and the risk cannot be mitigated by another reasonable accommodation. So basically what that means is if the employer says, I cannot provide you with this particular reasonable accommodation that you're requesting because it's a hardship to me, the employer does need to explore other reasonable accommodations that are not an undue hardship. And that's how the undue hardship aspect works, that even if one reasonable accommodation doesn't work, if there's another one that does work, then that accommodation has to be provided. Next slide, please. So we're going to go back to Michael, our employee at Trader Joe's. Michael works from 9 to 5 as a cashier at Trader Joe's. He's considered high risk for COVID-19. Michael asked for a reasonable accommodation to stock shelves overnight to avoid coming into contact with people. But his boss, Joe, would rather have Michael wear personal protective equipment instead of changing Michael's schedule. What should Joe do? Next slide, please. So in this situation, unless there is an undue hardship, Joe should grant Michael the reasonable accommodation. While Joe may prefer that Michael wear personal protective equipment, the EEOC requires that the employee's preferred reasonable accommodation be given primary consideration. Next slide, please. So here's a new example. Aiden has been an emergency room nurse at State Hospital for 8 months. Aiden tests positive for COVID-19 and he can't come to work anymore. What protections, if any, is Aiden entitled to? Next slide, please. So what would be an accommodation for Aiden? Leave of absence from work is an accommodation for Aiden. So the Family and Medical Leave Act and the California Family Rights Act provide 12 weeks of job protected leave for employees that cannot care for themselves or a spouse, parent, or dependent child with a serious health condition. Both the FMLA and the CFRA apply if there are at least 50 employees within 75 miles of the work site, the employee has worked there for at least 1 year, and the employee has worked at least 1,250 hours in the year before they need the time off. One of the differences I just want to note is that the FMLA and the CFRA The CFRA covers registered domestic partners and the FMLA does not. So with regards to caring for a spouse with CFRA, that also would allow you to take time off to care for a registered domestic partner. Next slide, please. So in this example, Aiden has only worked at State Hospital for 8 months. So unfortunately, he would not be entitled to the 12 weeks off under FMLA or CFRA to care for himself. Next slide, please. So I want to explore other options that Aiden may have. The first option is if Aiden has sick or vacation time, he can ask his employer to use that time so he can continue to be paid. An employer must consider unpaid leave and telework, which is working from home, as a reasonable accommodation. So Aiden can ask his employer for unpaid leave, or he can ask his employer to work from home if that's possible. Now, Aiden is an emergency room nurse, so there may not be any work that he can perform from home, so it's probably unlikely he can care for patients at his home, but there may be paperwork or other administrative tasks that he can perform from home, and his employer must consider that as a reasonable accommodation, even though Aiden is not entitled to the 12 weeks of leave under FMLA or CFRA. Next slide, please. So this example is with Gia. Gia has been a firefighter for 10 years. Gia is diagnosed with anxiety disorder that has worsened due to the stress of COVID-19. Gia tells her supervisor that due to her disability, she can only work 1 day per week as a reasonable accommodation, and she can resume full-time work after the pandemic ends. This is the first time Gia's boss was informed that Gia had a disability. Gia's boss says this is too short of notice, and if Gia does not produce her entire medical record by tomorrow, she will be fired. What are Gia's options in this situation? Next slide, please. So Gia's boss may inquire about her condition to determine if it is a disability, and he may request medical documentation to confirm that she does in fact have the disability and that because of her disability, she needs a reasonable accommodation. Due to COVID-19, the Department of Fair Employment and Housing recommends that employers waive this requirement until the employee can obtain the necessary documentation. This is because many doctors' offices are closed and it is very difficult for people to get in touch with their doctors and their medical team to provide any information as to why they may need a reasonable accommodation. So DFEH is recommending that employers waive that requirement at this time. But also it's important to note that the employer may only obtain information that is relevant to establish Gia's disability and her need for the accommodation. The employer cannot request Gia's entire medical record because that's unnecessary. Next slide, please. The other part of the hypothetical was that Gia's employer said this is too short of notice. Well, in this situation, it would be difficult for Gia to give any advance notice due to the pandemic. Employers must exercise sound judgment and follow recommendations from public health officials when considering reasonable accommodations. That sound judgment would include giving Gia additional time to get the documentation, but also recognizing that the pandemic is evolving and changing every day, every hour, and it is not practical for an employee to provide as much advance notice as they normally would if we were not in a pandemic. Next slide, please. So employers and employees must work together to determine a reasonable accommodation. This is called the interactive process. The interactive process must be conducted timely and in good faith, although it may be delayed because of the pandemic. But even if the interactive process is delayed due to the circumstances of the pandemic, it has to happen at some point. Next slide, please. So next we're going to talk about enforcement options. Next slide, please. There are multiple enforcement options that one may have if they have a complaint against their employer. So if you're in a union, the first step would be to contact your union representative and let them know about the problem. And they can give you any information about protections you may have. The next option would be to file a complaint with the Equal Employment Opportunity Commission, the EEOC. File a complaint with the EEO office if you are a federal employee. File a complaint with the Department of Fair Employment and Housing. If you work for a state or local government employer, you can file a complaint with the U.S. Department of Justice. And finally, you can file a lawsuit, in state or federal court. Next slide, please. And so now I'm going to turn it over to Stephen Peters, who's going to talk about considerations for DOR clients.
Thank you, Aisha and Pam. This is Stephen. So as Aisha mentioned, I'm going to be talking briefly about considerations for DOR clients as they identify a need for reasonable accommodations. So I would like to note at the beginning that we will be discussing DOR services in more detail over the next two trainings, but today we'll just be focusing on the DOR's potential responsibility to provide accommodations. Next slide, please. So the DOR may provide accommodations when an employer does not. Accommodations must be reasonably necessary to secure, maintain, or regain employment, and accommodations should be included in an individualized plan for employment. So a couple notes on this. So as Pam and Aisha mentioned, it is generally the employer's job to provide accommodations. But in circumstances where the employer isn't providing an accommodation or may not be obligated to for whatever reason, the DOR can step in. One thing that I think is important to note is that the DOR is generally only going to provide services to help someone achieve the employment goal that's listed in their individualized plan for employment, or IPE. So for example, let's say that I'm a chef and I'm a person with a disability, and I've been a chef for a long time, and I'm deciding that it's time for a career change, and now I'd like to be an attorney, and I apply for and am found eligible for DOR services, and I develop an IPE with attorney as the employment goal. So if I'm working with the DOR to achieve that goal, but I'm still working as a chef in the meantime, and I need an accommodation to continue working as a chef, the general rule would be that the DOR may not be obligated to help me with that because they're only assisting me with the employment goal to become an attorney. However, as advocates, we like to interpret regulations broadly, so there may be some leeway there depending on the individual circumstances, but that's the general rule. And then as a final note on this slide, as I mentioned earlier, we generally advise folks to include all services that they receive from the DOR in their individualized plan for employment, or IPE. So this is a good way to get things in writing and get things in the case record, and DOR clients have the right to request an amendment to their IPE at any time. Next slide, please. So before the DOR provides most services, it has to ensure that there's not a comparable benefit available. So a comparable benefit is a service that is paid for at least in part by a public program, health insurance, or employee benefits. It must be available at the time needed to ensure progress in the IPE, and it must be commensurate to DOR services. So just to talk a little bit more about this, so generally the DOR will not duplicate services. So if I'm receiving a service from another program, such as the regional center, or if my health insurance or my employer is providing an accommodation for me, then the GOR generally will not be obligated to provide that service again, so long as the service that I have is meeting my needs and I'm able to continue working or working towards my employment goal. Importantly, any accommodations I receive from other sources have to be available at the time needed. So for instance, if my employer says, great, we definitely want to provide this accommodation, for whatever reason we're unable to provide it right now, but maybe in a couple months we can examine that. So even though in this scenario my employer would be agreeing to provide a service at a later date, the legality of that aside, because it's not available when I need it, the DOR would be obligated to step in. Next slide, please. So this is just sort of to sum up the DOR's obligation here. So if the service is necessary for participation in training or employment retention and no comparable benefit exists, the DOR must fund the service. So one other note on this. So I mentioned before that the DOR is only going to be providing services that are necessary to achieve the employment goal listed in the IPE. However, if part of that is going to school or enlisting in educational training, even though that's not directly the employment goal, because that might be necessary to achieve it, then the DOR could step in to provide services to ensure that I'm able to continue participating because it's necessary for my employment. Next slide, please. So these are just some general additional resources as we wrap up here. So we have links on this on the slides. There's a DFEH fact sheet, which summarizes some of the information covered today as it relates to the California Department of Fair Employment and Housing. There's an EEOC fact sheet, which also has more information on the topics we discussed today. We have our own employment publications that we invite folks to explore. And then a resource that I personally depend on a lot and I think is great is the Job Accommodation Network. So this is a website that allows folks to search for potential accommodations based on job type or disability type or limitation. And the website for that is askjan.org. And then the Legal Aid at Work website also has a lot of great additional information on this. Next slide, please. And so if you are interested in receiving DRC services or have some additional questions about things that we covered today, we invite you to call our intake line at 800-776-5746 or to visit our website at www.disabilityrightsca.org. Next slide, please.
Thank you, Aisha, Pam, and Stephen for that wealth of information. At this time, we're going to answer some of the questions that you've included in the Q&A. If you haven't had an opportunity to include your question, you're welcome to do so now. We'll answer as many questions as we have time to, but as Stephen mentioned, you're also welcome to contact our intake line or visit our website so that we can answer your questions there. So we had a question, if someone is a healthcare worker and they have a high exposure to people who could potentially have COVID-19, they're also a person who may be at higher risk. What would an individual do if, for example, they asked for a reasonable accommodation to work remotely and that was denied?
So In this situation, as we discussed before, the employer needs to engage in the interactive process. So if the employer has denied the request from home, it's important to know why that is. Or in the example of Aiden, who worked at State Hospital, even if in that situation, even though Aiden couldn't perform his duties as an emergency room nurse at home, if there's other administrative tasks he could do from home, then the employer is required to consider that. So in this situation, it would essentially be the same. If there is another duty that the employee can perform at home, then the employer is required to consider that as a reasonable accommodation, and that's part of the interactive process. It can't just be a flat out denial without any discussion about what can be an accommodation that's appropriate for this employee. Pam, I don't know if you have anything to add, or Stephen.
Yeah, I agree with all that. And also, in a situation like this, possibly there is no way that she can work from home. We don't know enough about her job yet. If it's true that she can't, there's nothing she can do from home, then the employer does have to explore leave options with her. So maybe she is able to get FMLA or CFRA leave, or maybe she just gets unpaid leave as a reasonable accommodation. The one thing that's important to know also is she one of those people who, the question says that she has diabetes. If she's a person who is highly susceptible, as it's framed in the governor's order or in a local order, and she's not allowed to leave the house, like as if she were over 65, then that is an important consideration. Then the employer cannot bring her out of the house if the governor has told her to stay home. That's just another factor. But yes, she should also explore leave as a reasonable accommodation.
Thank you. And you mentioned FMLA and the CARES leave. There was a question about if those leave times are paid or unpaid.
Unpaid.
Okay. And can an employee be asked to use their sick time if they are taking leave or unable to work?
I'll take that. So if an accommodation can be very flexible. So if it does, the employee, excuse me, doesn't necessarily have to exhaust all of their sick time in order to get extra time off, depending on the situation. If the person has a lot of sick time accrued, then maybe they should, but that's a flexible thing.
And just to add to that, so FMLA and CFRA, those are job protected leaves. There may be options to get paid under short-term disability or using sick, vacation time, any accrued time like that. But the focus of FMLA and CFRA is that if you go on leave for a certain amount of time, which is up to 12 weeks under both of those regulations, then you will have a job when you come back. And it's that the employer has to keep the job open for you.
Right. So if you have sick time, that's paid leave. So you might choose to take that before you go on an unpaid leave.
And there's also a question, if someone is put on a medical leave by their doctor for a chronic condition, how long does the employer have to hold the job?
Pam, do you want to take that one?
Oh, sure. It depends on how long the doctor says the person's going to be out. So if this is a reasonable accommodation situation where the person's requiring time off as a reasonable accommodation, or a reduced work schedule or something like that because of a condition, then it's for however long the person's going to be need that change, unless that's an undue hardship. And that is going to depend on the circumstances.
We have another question related to leave. If someone is a parent of a child with a disability who is currently out of school, does the workplace have to provide accommodations or leave time in order for that individual to stay home with their child with a disability?
You want me to take this one, Aisha?
Yeah.
Yeah, so unfortunately, reasonable accommodations are only available to people with disabilities. You cannot get a reasonable accommodation to take care of someone who has a disability. So there are other ways for this individual to try to get accommodations if this person, the employee herself, has a disability. If the person doesn't have a disability, I mean, everyone is in a tough situation right now if you have children, because you're trying to take care of your children and work at the same time. It's just a very difficult situation. The laws that we're talking about today only apply to employees or job applicants who have disabilities. So in this situation, we don't know that the employee herself has a disability, but you know, she can still explore with her employer ways to change what she's doing, because you know that every employee who has children is going to be in this situation.
I would also recommend last week's presentation.
Thank you, Aisha, for that reminder. Yes, if for those of you who were not able to join last week, our session is posted to the website, and we did talk about some of the COVID-19 employment benefits that are available to people who are sick with the virus themselves, caring for an individual who is sick with the virus, and also parents of children who are out of school or who do not have childcare. So please visit our website to view that presentation. I'd like to shift now to a question about the example that was given for Joe. One of the details in that hypothetical was that Joe had asked to work on a different shift so that he would have less exposure to the public. The question is, what if the employer did not need additional people working the alternative shift?
So in that situation, the employer would have to prove that it's an undue hardship to have Joe as one additional person working the night shift. It can't be a strictly financial burden for the employer. So the employer would have to explore, you know, would have to show that this is an undue hardship for me to have Joe as an additional nighttime person. That may also involve the employer changing the schedules around for the people that do work night shift if they're able to take Joe's 9 to 5 shift. So it's just part of the interactive process and figuring out what is a reasonable accommodation for Joe, and how they can reach sort of an amicable resolution for everyone.
And a related question, if someone changed their work setting, for example, they worked on a different shift or they opted to work from home and their employer cut their hours, what options or accommodations are available?
Pam, do you want to take that one?
I'm not sure exactly what that's getting at, but I will say that another way to look at what Aisha just said is that employers have to give accommodations that will allow the employee to fulfill the essential functions of their job. So if the person who wants to work in the night instead of at the cashier job, the question is that nighttime stocking shelf work part of their job description? I happen to know that Trader Joe's has very broad job descriptions where you can do a lot of different things as a team member at Trader Joe's. So to answer this question, if you are doing different tasks within your same job, then the same rules apply as always. You have to be able to do those jobs effectively with the accommodation that you're granted. If you're actually changing jobs within the company, that also can be sometimes a reasonable accommodation, although job reassignment, I think, is not a favored accommodation, but it is possible. If that happens, then you have to do the job that you're now in. Rebecca, do you have a better idea of what the question was?
So the person is an essential worker serving the public, and their hours were cut when they were asked to work from home due to an existing health condition.
Oh, their hours were cut.
Mm-hmm.
Well, that in a sense is a form of unpaid leave. It's what's called intermittent leave, which is some of the hours that the person was working are now leave hours, essentially. If that's the arrangement that they made with the employer, that's fine. If they don't want the hours to be cut, then the employer has to allow them to try to allow them to work as many hours as they're capable of working, with whatever reasonable accommodations are necessary to put that in place.
I would also note that this person may be eligible for partial unemployment if their hours were cut due to the COVID-19 pandemic, and that topic was discussed on our webinar last week as well.
Right.
Another question, if the employer would generally provide the PPE, but the PPE is not available due to high demand or lack of PPE on the market, what can an employee do in that circumstance?
Well, you can't get blood from a turnip. So if there is really no availability for something, then the employer can't be expected to get it. The employer has to try as hard as they can to provide protection for employees. If they can't, then they have to rearrange things so that people are safe.
Okay, and the last question that we'll have time for today, if someone does test positive, is the employer obligated to notify public health or other employees at the worksite so that those individuals can be tested?
So the employer, yes, can notify the local public health agency to let them know that the person tested positive. In regards to informing other people at the workplace, the employer also may disclose that someone tested positive, but they may not disclose who that person is by name or any information that would make it so that a colleague could easily identify that person. So if the person had a very particular description, the employer cannot say, oh, it was the person that looks just like this, but I'm not saying that person's name, because that's identifying information. They can only say this person tested positive, was in the workplace for during this time period, and so you may have been exposed.
Thank you. And thank you everyone for joining us. At this time, I'm going to share with you our website so that you can locate some of the resources that we discussed today, as well as find information about our webinars. So as you'll notice on our homepage, we have a banner that links to all of our COVID-19 resources and information. We also have a link here for self-advocacy publications, some of which were mentioned in today's webinar. And then as you scroll down, under the section Announcements, there's a link here for webinars. And if you'd like to find the recording and publications for last week's webinar, you can click on this link, Past Webinars. And you'll see here is our employment, benefits, and Social Security presentation. And for information on our upcoming webinars, you can click on the link Upcoming Webinars. In addition to our employment training series, we have several other topics listed here. The next session in this series will be Employment Services for People with Disabilities on May 12th. And then following, Services to Help You Keep Your Job on May 19th. Thank you again, everyone, for joining us. And please know that we are in this together, and you're welcome to contact us at our website or intake line so that we can assist you. Thank you.